One of the most common questions I am asked by clients is whether they should have a will or a trust. The answer to this question depends on what type of property you own. A will and a trust function similarly in that they will direct the distribution of your property after you pass away. Both documents leave your written instructions about things like who shall take possession of your property after you die and who shall be put in charge of your estate. However, the way that these documents complete these instructions are very different. A trust is a document written in a way that allows an individual's heirs to avoid a court process called probate. Probate is a court process that functions to move property out of the ownership of a deceased person and into the ownership of his or her heirs. Because a trust can be the legal owner of titled property such as your home, your car, and your bank account, if when you die all of your property is owned by your trust, your estate will not need a probate. This is because you will die without having personal ownership in anything, having shifted your ownership to be titled in the name of your trust. In contrast, a will is simply your written instructions, much like a letter or a written affidavit. This document cannot own property, it can only distribute it. This means that although your estate will eventually be distributed to your heirs, your estate may have to go through the probate court process first, especially if you die with a home, vehicle, or bank account titled in your name. An experienced estate planning attorney can assist you in determining which document would be best for your circumstances.